with constitutional rights, it perverts this entire framework. It means that we, the people, through our elected representatives, are no longer able to appropriately control commerce and business. And that's why, and to be clear, the history of corporations claiming constitutional rights is replete with examples of local, state, and federal laws being overturned, laws that have attempted to protect the environment, laws that have attempted to prevent so-called big box stores from coming in to businesses, from communities, laws that have attempted to protect the quality of our air and our water, laws that have attempted to protect workers. There are hundreds, literally thousands of laws, if you count state and local laws, that have been already overturned because corporate lawyers argued that the elected representatives' efforts to control their conduct actually ran afoul of the constitutional rights of concentrated capital. Because let's be clear, again, I believe in the use of the corporation for commerce, but all it is a way to organize capital in order to get things done. It is not a human being, so there cannot be civil discourse with a corporation. It doesn't make sense. And that's why, at the end of the day, when corporations can claim constitutional rights, it perverts that promise. And 1 year ago, on January 21st, the U.S. Supreme Court's decision in Citizens United versus Federal Election Commission really showed just how outrageous this legal doctrine is. Because it's not a law. It's never been a statutory law at the federal level. Congress never made a law granting corporations this much power. It's always been court-created, judge-created common law. And in that case, the very anemic campaign finance laws afforded to us federally by McCain-Feingold were overturned. And remember, $5 billion, that's $5 billion with a B, had already been spent in 2008. And the court said, and I'll quote the court's decision, the court said that the McCain-Feingold law treats corporations as a, quote, oppressed minority. Now, can you get your head around that? I mean, that is outrageous. Why did they use that language? As a lawyer, I can tell you, in order to come under the rubric of some other federal law that says that in order to overturn a legislative pronouncement, you had to actually, you had to find such language. So they simply found it. So what Senator Lyons is proposing to do is a resolution. And I want to share with you what is the good news as somebody who's been traveling around the country since this decision came forward. And that is, there is a growing movement in this country that realizes it's not enough to try to handle corporate harm or abuse one law at a time. We need to change the framework, the rules, because currently the rules allow corporations to overturn laws even if they have gone through the difficult legislative process. And by the way, thousands of laws have already been overturned. Likely tens of thousands of laws were never passed for fear, the chilling effect that our legislators have suffered under because corporate lawyers have threatened to sue them. So there are right now 100,000 Americans who have joined for a peaceful revolution to assert our democratic right to sovereignty, our ability to be able to say it is our right to decide how commerce should take place within our communities and within our states. And it is illegitimate for the federal courts to tell us that we cannot control the corporate form. And that is manifesting in a call to amend the U.S. Constitution to make it clear once and for all that, and as a civil libertarian, that absolutely people should always be free from encroachment of their civil liberties by governmental action, but only living, breathing human beings should be able to claim that. Let me tell you, folks, there's not a single one of the founders, there's not a single ordinary person who has a problem understanding that. As a lawyer, I'll say it seems to be only lawyers who have been perverted enough to think that somehow this makes any sense at all. So let me just end with this. Already there are local communities passing resolutions. We are asking Vermont to pass a non-binding resolution in order to set the stage for the kind of discourse and debate and discussion that ought to take place about the proper role of the corporation. We're not at this point asking for binding law because, and I'll say as an organizer, and I know that there are several organizers turned legislators in this room, we're not ready. We need, but we are ready for you to help hold up something that we may aspire to. Just as the Declaration of Independence was a resolution, what we're asking you to do is to be the first state to pass a resolution that says it is the sentiment of this body that this legal doctrine is simply a bad idea. And because the Supreme Court has claimed the ability to interpret our Constitution, then it is the sovereign right of the people to amend that Constitution in order to correct them. Just as that's been corrected when the court said women were not persons under the 14th Amendment, just when they said that African Americans were not persons, it is time now to correct the U.S. Supreme Court. Yes, sir.
I have two questions for you. First, just to be clear, that this is actually not really, this is not primarily about campaign finance. Because if it was, in addition to stripping corporations of personhood, you obviously would want the amendment to do other things. You'd want campaign finance reform, for example, limit the amount of contributions in self-funding, require transparency, and you aren't doing it. So
we are. It's parallel, not here. But you're right, we're not doing it with this one. We support those things.
But I mean, it's not part of this movement. So this is really going to something, just to be clear, so we understand it, that the pending resolution is going to something much more fundamental than reversing Citizens United. And in fact, it really doesn't address, it does not address many of the issues of campaign finance. For example, it wouldn't actually make legal the Vermont law that was overturned by the courts.
I think that's right, and I want to be clear. Yeah,
okay.
Yeah, but since you've given me this opportunity, I want to be clear, as somebody who lobbies for and works on campaign finance, and this is why it is not either or, and as legislators you do this all the time, it's both and.
I'm not disputing that.
Yeah.
Can I go to my next question, which is, as I listen to what you're saying, the truth is that something else is really the problem, which is the Supreme Court. Mm-hmm. Let's be honest about it. If there's anybody who believes that Bush v. Gore would have been decided the same way if it had been Gore v. Bush, what we fundamentally have is a political institution which makes its legal decisions based on the outcomes it want, and not as would be in the case of the courts, on a neutral interpretation of the law.
Agreed.
Well then, wouldn't it make more sense to have a movement that actually allowed elected accountability over the Supreme Court rather than something that is so narrow? I mean, in other words, you have a court, Citizens United was decided by one vote, reflecting the ideological preferences of the judges with no review. Bush v. Gore was decided by one vote, reflecting the desire of the justices to have George Bush become president instead of Al Gore. Surely, you ought to be thinking about going to the root of the problem rather than around the edges.
Well, with respect, I think that we are going to the root of the problem when we talk about, because for me, what I understand is that the corporation is actually the dominant institution of our culture. It is actually more pervasive than virtually any other institution. So as it relates to whether or not we should be electing federal judges, I'd be willing to entertain that debate, sir. But I think actually that this is a much more systemic approach. It's not the only thing, but it is, in our opinion, the idea that corporations have become somehow governing entities that are actually able to claim inherent constitutional rights. That is a systemic first principle that we simply don't agree with.